Good evening, everyone. A very welcome to you all from Bangladesh Institute of Research and Education. As we know, to celebrate the 50 years of the Supreme Law of the Republic, the Constitution of the People's Republic of Bangladesh, Bangladesh Institute of Research and Education has been organizing this event of series discussion. So till today, a total of 14 series discussion has been organized on many topics. Well, the number is 15 since 14 has already been discussed. And the title of today's topic is Bangladeshi Course and Religion in Comparative Perspective. Well, hopefully this session is going to be very special and enlightening for you because we will be getting to see the Bangladeshi course and religion from a comparative perspective. So who do we have with us? Well, let's see. This is Mr. S.M. Faisal Kamal, who is currently who is a Ph.D. candidate in the Department of Political Science at the University of Toronto. So his fields of specialization are comparative politics and Canadian politics. Well, prior to coming to Toronto, Mr. Kamal completed an MA in political study from Queen's University at Kingston. While here he researched on the partition of India as a case of state contractions and downsizing. His current dissertation lies at the intersection of comparative politics, jurisprudence, and legal theory, public law, and religion. Well, this examines how appellate courts in Bangladesh and Pakistan have defined, structured, and imagined religion in their jurisprudence. So obviously, as you can see, our title is Bangladeshi Course in Religion from a Comparative Perspective. And Mr. Kamal dissertation topics, they are in the same things. So definitely at this end of these sessions, you will be knowing a lot more than what you know about the Bangladeshi course in religions. And as I have already said, this is a very special session because this session is focused on a comparative analysis. So before I hand over the floor to Mr. Kamal, we will let the audience to know that at the end of this session, Mr. Kamal will be speaking for an hour, and after that, we'll be taking questions from the audience. So if you have any questions, please feel free to ask, and Mr. Kamal will address them. So, Mr. Kamal, and we're handing over the floor to you now.
All right, thank you, Basha, and thank you for Bangladesh Institute for Research and Education for having me and giving me an opportunity to share some of my interests in research on law and religion in Bangladesh in a comparative perspective. So when I was asked to give a talk on this, I was thinking of a way to actually talk about law and religion in a way that speaks to the different themes, but obviously it's not possible to cover every single issue that falls under religion when it comes to Bangladesh. So what I will do is I will talk about the relationship between law and religion through the prism of 5 cases. They were selected not in any very particular scientific fashion. So it's not as if I have a very good justification for why I picked these over others. I could have very well picked another set of cases. But what I do think these cases do is that they provide us with a window or an avenue to examine the type or kind of issues that come up before courts and how courts address them, both in Bangladesh and in other cases where similar issues have arisen. So this also means that although we're just looking at these 5 cases, this doesn't obviously mean that other issues don't come up, and they actually do. So I would be happy to bring them up, or if you have any questions about other cases, I would be happy to talk about them in the Q&A. So I just wanted to sort of say that disclaimer so that people are aware that these are just 5 cases, and the story of Bangladesh law and religion can be told from a very different perspective if we selected another 5 cases, for example, instead of these ones. All right, so keeping that in mind, let me just begin with the first case. which is really a case about the freedom to make a will or testamentary power in Bangladesh. The name of the case is Abdus Samad versus Ching Si Cha. It's a case from '91 that was decided in 2015. So there's quite a bit of a span between the first appeal and when it was eventually decided. It's a case from the High Court Division of the Supreme Court. And the reason why I think this case is fascinating is because it speaks to the problem of the clash between what you would call rights of individuals versus religious or customary law that limits the power of an individual to dispose of their wealth. So I'm assuming most of you would know that in the Bangladeshi context, in particular in Islamic law, the power to dispose of wealth is fairly limited and circumscribed. At least within the Sunni school, the power is limited to 1/3 of your wealth or estate. So you can't give away more than 1/3 of your wealth. And there are further restrictions in the sense that you can give or apportion a share to someone who is in fact a Quranic heir. So these are some of the limitations that come up. So this case, interestingly, is actually not about Islamic law, but it's on Buddhist Burmese law, customary law. And in particular, it's the succession part of the law that is of concern here. But although this case is not on Islamic law, I think it speaks to the problem of testamentary power in basically any customary or religious law that might come up before courts in Bangladesh. So the issue in the case is essentially a will which was made by someone who had died and left behind, a certain piece of wealth, which was to be used by the heirs, including 2 children, wives, sisters, children of sisters, and so on and so forth. And as is usual in family cases, especially that have to do with wealth, there was a dispute over who could control or what portion of the wealth that they're actually assigned from the estate. And in this case, there was a probate done of the will, and then it was eventually revoked. And the question was now who is entitled to this property, especially to the benefits that would accrue from the property. And the case turned on the question of do individuals in the Buddhist Burmese tradition have the right to make a will in the first place? Because if their law, their customary law, religious law says that they don't have this right, then the entire case falls, because then there is no legal validity to the will that was actually made. And the courts had to determine what's the status of a will in that tradition. And after sort of reviewing the history of Buddhist Burmese law in South Asia, in particularly in India and Bangladesh, it came to the conclusion that, in fact, within Buddhist Burmese law, individuals don't have the power to make a will. So testators are severely limited in how they can dispose of their wealth. And so this is a case where the entire will was kind of considered void and is not recognized or is not enforceable. And I think the relevance in this case, again, is to what extent individuals have freedom to dispose of their wealth. And the reason why it's important is because if we compare this to English common law, there you will find exactly the opposite, where you have full and complete testamentary power, and courts are very hesitant in intervening in matters regarding wills and either changing it or disregarding it, because they hold that one of the hallmarks of English common law is giving the individual as much freedom as courts can in deciding how they dispose of their wealth. This obviously wasn't the case 2 centuries prior, because this particular freedom only originates in 13th and 14th centuries, and then fully develops only really in the 18th and 19th century, where English common law takes pride in the fact that one of the liberal principles of this law is a person has absolutely complete freedom in how they dispose of their wealth or want to divide their wealth after they die. And the courts are very hesitant, as I said, in intervening in these matters. So they will uphold the will in almost 95% of the cases, unless a very compelling case can be made that the substance of the will, if you execute it, it would probably go against public policy. But those are extremely rare cases. What this freedom allows, of course, is that in English common law, at least, you could limit the type of property that would pass on to your heirs depending on their religious affiliation. So you could potentially discriminate against individuals, against your own sort of children or spouses or grandkids, by placing conditions that if my, for example, son converts into a different religion, he was born a Catholic but becomes a Protestant, or he was born a Hindu, becomes a Muslim, in those situations they would be barred from inheriting anything. So these are limitations that are actually that are quite common, particularly in places where there is a clear sectarian or religious divide between groups. So, for example, between Catholics and Protestants, or between Hindus and Muslims. And in those cases, courts, although they dislike the fact that testators have left a will that basically discriminates on the basis of religion, they nevertheless uphold it. In Bangladesh or in much of South Asia, of course, we know that rules can be very stringent. Testators are not given such freedom. And of course, there's also the fact that change of religion could or could not sort of allow you to actually inherit from the estate. And I just want to make a final comment about Islamic law in this regard. So we know that up until this day, Bangladeshi courts have upheld the fact that they will declare any will void that goes against the Islamic law of inheritance or succession. So if, for example, a will contravenes the 1/3 rule, or if it actually makes or names someone who would be a Quranic heir and makes them a beneficiary of the estate, the wills would be considered void. So these, so even to this day, if you are a Muslim, just like a Buddhist, so in the case of a Buddhist Burmese, you're basically very much restricted in how much you can dispose of wealth, right? Because the power of will is kind of absent. In Islamic law, it's not absent, but it's very much restricted. And so if you make a will that goes against it, and if it gets challenged in courts are very unlike, it's, as far as I know, they would probably not uphold a will or apply a will that goes against Islamic inheritance law. Of course, if it's challenged. It's a different matter if it's not challenged in courts, in which case nothing would probably happen, and the property would get divided as was decided between the heirs. So this is, I think, a case, an important case about how religion has a very substantive role to play in the context of Bangladesh. It's not ceremonial or like symbolic. It's not nominal. Religion can, in fact, restrict the rights of individuals in how to dispose of wealth. And so you can't use a religious freedom argument in Bangladesh today to say that I would like to dispose of wealth in whatever manner I like, because you are very much restricted based on the religion that you follow or you've declared. So this is an issue. It's a recurring issue. It will come up, of course, because as societies progress, we have seen that there's less of a tendency to apply these religious rules, especially if they become complicated. They don't have to be, but they could become complicated, in which case I think there might be more of a demand to give more freedom. But as things stand right now, it's not entirely clear. Just to give you a very unscientific survey, when I was doing fieldwork in Dhaka for my own dissertation, one of the questions I would ask lawyers and judges would be, imagine a scenario, it's obviously hypothetical, but imagine a scenario where a person goes to the court and says, my understanding or my interpretation of the Quran is that daughters should get an equal share as sons from my inheritance. And given the fact that the Bangladeshi constitution protects my religious freedom, so it's a guaranteed right, I desire that my property should be divided based on my interpretation of the Quran or Islam. Is this something that the courts would uphold? And by far, almost all of them, all the judges and lawyers that I spoke to would say that this is very unlikely. But even if someone were to come up with a case like this, courts would be very hesitant in saying that we will allow you to dispose of your wealth based on your sort of religious idea or interpretation. Instead, they would just stick to the canon and apply the Islamic law or the Hindu law or whatever law is applicable in that case. All right, so that's the first case that I wanted to discuss. The second case has to do with religious conversion. So this case, the name of the case is Bhakti Bhushan Shaha versus Maulana Ruhul Amin. So this is a case from 1985. So it is obviously a quite old case, but I think the reason why this case is important is it speaks to the question of whether minorities have roughly the same right as majorities, or is it implicit whether they have the same right or not. So in this case, a minor boy who belonged to a Hindu family was studying in a college or high school, SSC. I think that's high school. I don't know. I could be mistaken. So this person, this kid, he is in college. He's writing his exams. And then one day he decides that he will convert into a different religion, and he adopts Islam as his religion. So he's a convertee. And once he converts, his father gets to know that my son has converted, and he's a bit concerned because he thinks that A, the boy is a minor, according to Bangladeshi law, and B, because any parent might be concerned if all of a sudden they get the news that their kid has adopted a different religion. I think for the vast majority of people in Bangladesh and much of South Asia, this was come as a shock. So what happens in this case is that the father files a case in the court and argues that the custody of the kid should be handed over to him, but the boy refuses. He makes the argument that I have chosen Islam as based on my own free will, not in any pressure, and I want to remain a Muslim for the entirety of my life. And I suspect and I fear that if I were to go back to my father, or if my custody was handed over to my father, that my father would not let me remain a Muslim. That he would compel him to go back to his previous religion, Hinduism. The father, of course, makes the contrary argument, where he suspects that the boy was converted under duress, that there was some kind of fraud involved in this, and that people probably compelled him, and he came in under the influence of others, and that's why he converted. So it's not a conversion out of free will, but out of compulsion. And so now the court has to decide, of course, that what do we do in this case? Like, do we hand over the custody to the father? In which case the religious rights of the boy might be curtailed, or do we uphold the right of the parent to have custody of the children, especially of minor children, and to decide their fate, especially in matters of religion? In this case, the court sided with the boy. They argue that they agree with the boy in the sense that after hearing the boy and the other parties involved, they determined that there doesn't seem to be any sign that he was forced or coerced into adopting Islam, that he did it out of his own free will. And so if that's the case, and if the boy thinks that if he were to go back, he might not remain a Muslim or might be forced to convert back to Hinduism, then he shouldn't be awarded custody to his father. The other thing that they determined was whether or not the boy can sustain himself. And interestingly, they said that, yes, the boy is tutoring on the side, and so he has enough money or income to support himself, because that was the other consideration. And I think the reason why this case is important is because this is a case where the courts, as I said, it's an old case, so we don't know the entire sort of history or facts. But what we do know is that the courts were pretty much satisfied with what the boy had to say, and I think perhaps this might be okay. But in other cases, perhaps you have to dig deeper to see what's actually going on in these cases. Is there compulsion or coercion involved? The other thing that's important and interesting about this case is consider the opposite scenario where a Muslim boy converts to Hinduism in Bangladesh, and then the Muslim parents or one of the parents demands that the custody should be handed over, and that they would compel the kid to revert back to Islam. Is this something the courts would be willing to do? My sense, and I could be wrong in this, is that this, first of all, it would be a very politically explosive case, because if the courts were to side with the child who converts into Hinduism, especially from Islam, this might invite trouble, politically speaking, even political and legal mobilization on the part of different parties, because these kinds of cases become big precisely because they invite or attract different actors who are looking for cases or opportunities to mobilize for their own sort of legal political causes. And it's not entirely clear whether courts would do that, or they would be successful in doing it because they might be pressurized otherwise. So that's one. But the other issue here is, of course, the fact that to what extent parents should have the right to teach their own religion to their children. Is this something restricted? At what point children can disagree with the tradition in which they were born into, or the parents, the tradition or religion that was followed by the parents, and at what point the courts would say, well, yeah, you have the right to follow your own religion, even if it's something that's different from what your parents, believe in. These cases, I'm sure there are conversion cases that have come up since. This is an old case from 1985. And perhaps the courts are consistent in that most of the cases, I suspect, have to do with religious conversion from Islam to Hinduism and not the opposite. But it would be interesting to see what the courts have to say if the opposite were the case. These cases can be compared to conversion cases in the Pakistani context, where in the last 5 or 10 years, there have been a lot of cases of forced conversion. So there, like in Bangladesh, religious freedom is guaranteed, but the main difference, of course, is that the state is not merely an enabler of religious freedom, like in the case of Bangladesh, but it's also a promoter of Islam. So it's a promoter and protector of Islam. So these are two different what you would call roles of the state. If the state is an enabler, it's simply providing an enabling environment to all its citizens. It's creating a level playing field for all of its citizens to enjoy their religious rights in peace and harmony, unless, of course, they disturb public order. State that is not just an enabler, but also a promoter for specific religion, there, of course, things might be more complicated. So in the Pakistani context, there are these cases, especially in the province of Sindh, where minor Hindu girls are sometimes abducted and forcibly converted. But when the matter reaches the court, and they're usually converted for the purposes of marriage, like someone wants to marry them, usually a guy who is much older to them. And when the matter reaches the court, over there, the courts have a very hard time determining whether or not the conversion actually happened out of the free will of the person who converted, or whether it was under duress. And in those contexts, the issue is that if the child or the girl says that I chose Islam out of my own free will, then courts are somewhat limited because they suspect that if they were to reverse the conversion or not to accept it or to award the custody to the parents, they might invite controversy or trouble, because again, conversion from Islam to another religion might seem controversial. But we don't know how courts will react in the future, but the trend seems to be that if a person can prove in the court of law that the conversion was more or less free, then the courts are kind of they don't really have much choice. But at the same time, we know that courts are not completely helpless, that they can simply turn a blind eye to and take everything at face value in terms of, especially in terms of evidence, that they could on their own accord investigate a little deeper to see what's actually happening, right? Is this simply a case of a person claiming that they've converted out of their own free will, or is there something more to it? Okay, so that's the second case that I want to discuss. It's a case about religious conversion, the right to convert into another religion, the right of parents to impart religion on their children, and so on and so forth. All right, so the third case that I want to discuss is, it's called Jogmaya Saha Roy versus Sri Shekhar Chandra Chakraborty. And I apologize if I am mispronouncing any of the names. Please do correct me. All right, so this case is, again, another very interesting case. So this case has to do with succession law, but it's different from the Buddhist Burmese case that we discussed earlier, because in this particular case, what's really happening is that there's a person who has died, and there was a savings account in his name, and the nephew of the person now claims that he is the sole successor to the estate of the person who had died. And the courts now need to determine what are the actual facts of the case and how do we decide this. So the reason why this case is interesting is because the person in question who had died and who had left an amount of, I believe, 7 lakh taka in his bank account, it's claimed by one of the parties that the person had become a sannyasi or an ascetic or a monk. I'm not sure what the Bangla, like if I'm saying it right, whether this is in fact the term that's used, but at least that's the term that was used in the judgment. So again, please feel free to correct me on my pronunciation. So the question in this case was, if a person becomes a sannyasi or an ascetic and essentially is religiously ordained into an order, or is inducted in a religious order or a particular lifestyle that he or she has adopted, does that extinguish their civil rights as well? Right? The fact that you have become or opted to be an ascetic or a monk, or that you have been ordained into a religious order, does that mean that you're no longer a citizen? Like the laws of the country do not apply to you as a citizen because you have decided to renounce worldly affairs, go into isolation, and practice or conduct your life however you want? Like what's the actual implication of you being inducted or ordained in a religious order? Or you opting for a life that means complete seclusion and being cut off from the world? Like what are the implications of that in real world terms? So the person who had died, the person in question, one of the parties is claiming that because he adopted an ascetic lifestyle, he became a monk. According to religious and customary laws, he basically renounced any kind of claim to property. So in other words, once you become an ascetic, there's basically no claim to wealth that you can make because you renounce everything. In fact, the entire point of becoming a monk is you basically rely on charity to survive. You don't accumulate wealth. There is no greed involved. In fact, wealth accumulation is considered a sign of greed that would keep you away from the actual ultimate mission, which could be any number of things. But the point is that you are doing it for a larger purpose, and that's why you've adopted this lifestyle. And in doing so, you've given up claims to any kind of wealth or property. So that would include bank accounts, property, land, marana shares. And sometimes you could even say that the person no longer is no longer related to any of the other relations he or she might have had. So in this case, this nephew comes up to the court and says, I am the legal heir to this property, especially the savings that are left in the bank account. And so I should be awarded this entire amount because there is no one else to claim this property. And in this case, the courts have to determine, okay, what's the impact of this? Like the fact that a person is claimed to have become a sannyasi, does that mean that he gave up control over his savings account, and therefore the savings account, like the money in the savings account, cannot be given to the nephew? And in this case, there are two sort of questions. One is the larger question of what's the implication of you becoming a sannyasi, and the other one is what are the steps? Like, how would you prove that someone has in fact adopted a particular lifestyle? Because then this is a question of procedural law. But if you, like, for example, in religious conversion, if someone says that I've become a Hindu or I've become a Muslim, sometimes the courts can administer tests, sincerity tests, like, in fact, were the proper procedures followed or not. So in this case, there's like a 4-part test, and the nephew says that these steps were not followed, and in fact he did not become a sannyasi, and that's why I'm entitled to the wealth that was left behind. The other party claims that no, that's not the case. So there's the question of procedural law. How do you determine that? Like, how do you need to fulfill all the 4 steps for you to be declared an official ascetic, or is there something more to it? Like, if you want to become a monk, does there need to be a ceremony? Do you need to be inducted? Should it be recorded somewhere in a monastery or in a religious order that you have become a monk? Like, is there something to it? Or is this more of I proclaim that I have renounced everything in the world and that is sufficient for this to come? So in this case, it's not clear. Like, it's not clear that the person has followed all the 4 steps. But the larger point here is that the court concludes that there is circumstantial evidence to show that this person, in fact, adopted this particular lifestyle, renounced everything else in the world, and therefore the nephew is not entitled to this money, because once you have parted from the wealth, it no longer remains theirs, and so there can be no other person who can claim as a successor, because a monk cannot inherit from one and cannot be a successor to another, right? So that's or cannot leave wealth to another. So this case, as I said, it's the reason why it's important is because it asks the question: if you were to become part of a religious order or you adopt a certain lifestyle, does that extinguish your civil rights? And I think this can be compared quite directly to a lot of cases that come up in Sri Lanka, which is a Buddhist majority country where monks are regulated by statutory law and Buddhist law. And they maintain a lifestyle that's roughly separate from the life of normal citizens. So normal citizens can enjoy all sorts of rights, but the rights of Buddhist monks are different. They're protected by the law, and their behavior is highly regulated. So they could be punished or penalized if they were to contravene any of the principles of this. So in Bangladesh, there are 2 cases that are similar. So they're similar. They're not exactly the same. So they don't exactly ask the same question, but the larger question or the problem is similar. One is a case where a monk who is a certified monk, so there is no doubt that this person is actually a monk. He's ordained. He's inducted in a religious order, and he writes. So he goes to a law school, studies for law, and then is called to the bar. So he will now become a lawyer, practicing lawyer. Now, some monks or some religious organizations, Buddhist organizations, are concerned that by virtue of being a monk, this person is not entitled to pursue a worldly career, because that would be contrary to the principles of a monk's lifestyle. A monk is not supposed to pursue or indulge in worldly affairs. And by becoming a lawyer, the monk is kind of breaking that cardinal rule that I will engage in now secular activity. And monks are not supposed to be doing that. And so in that case, there was a lot of controversy because there were these religious organizations, there were Buddhist monks, there were ecclesiastical organizations involved, and they really were arguing that there is a duty on the part of the Sri Lankan state to protect Buddhism, especially if monks deviate from the expected rules or norms that guide their behavior. In that case, interestingly, the court sided with the person who wanted to become a lawyer. So, in fact, his call to the bar was upheld, but not without controversy. This obviously generated controversy because it divided people on the question of what can monks do. But the more interesting case, and these cases, by the way, if you want to learn more about these Sri Lankan cases, I highly encourage you to read Benjamin Chantal's new book. Well, it's no longer new. It came out in 2016. It's called Buddhism, Law and Politics in Sri Lanka. And it's a fascinating case because although the majority religion is different, a lot of the questions that come up in Sri Lanka are similar to the ones that come up in Bangladesh. So this case that I want to compare the Jogmayar case with is the case of a monk who, so his name is Vimala Vansa. So Vimala Vansa is a monk in Sri Lanka who, again, there is no doubt about the credibility of this person being a monk. He is applying for a driver's license. Why? Because he has a lot of duties. He needs to preach. He needs to be at the temple. He also teaches at a college. So he needs to be at different places at different times. And he can't really rely on public transit because public transport is not very good. Buses are always late. And so there is always this problem of, you being late everywhere you want to be. So this person thinks that, okay, if I were to apply for a driver's license, I can probably buy a car, and then that way I can avoid the problem of traffic congestion, I can avoid the problem of poor public transit and infrastructure, and I can get to places, I can fulfill my duties without much trouble. Of course, he thought at the time that applying for a driver's license was pretty much a harmless act, an innocuous act that wouldn't invite any controversy. But of course, in the first case, it did. Here, the problem was that the argument was that by virtue of being a monk, you can't drive a car because driving a car is considered a secular activity. And so if you were to do that, you would contravene the principles of the monastic order or law that governs the lifestyle and behavior of a monk. So there were these cases where, in this case, different parties, religious parties, religious organizations, and in particular, organizations that claim to represent Buddhist ecclesiastical law, they become party to the case, and they want to argue against this monk because they think that if the state allows this person to have a driver's license, what's next? They could then claim to do anything which would be secular, but in fact would break the monastic code. And so the question then becomes exactly the same in the Sri Lankan case as in Bangladesh, which is, what is the effect of you being a monk? Do you sever your ties? Are you no longer a citizen? Are your civil rights protected? Or does your status as a monk supersede or contravene any rights you might enjoy as a normal citizen? In the Sri Lankan case, Vimala Vansa, the monk who had applied for a driver's license, argued that the fact that I'm a monk has nothing to do with the case because as a civilian, regular civilian, I am entitled to get a driver's license. So I'm not applying for a license based on being a monk, but based on the idea that I'm a regular citizen as well, and my rights as a citizen are protected by the Constitution. So perhaps a similar case could have been argued in the Bangladeshi case, where imagine if the monk had not died, or the ascetic had not died, and had argued that although I had adopted this lifestyle, I no longer adopt it. What would courts do in that sense? Like, would they uphold this idea that a person can freely be ordained in a religious order and then exit as well without any trouble? Does that mean you no longer enjoy civil rights? This is a question that, again, would be something that will come up again and again in courts. All right, so we are done with 3. So the 4th case that I want to discuss is a very, it's a criminal law case. for those of you who might remember, in the early years of the 21st century, Bangladesh was hit and rocked by quite a few terrorist attacks, and there was a rise in the activity of what you would call fundamentalist or extremist groups. A lot of them were Islamic groups. Some of them were inspired by other Islamic movements, transnational Islamic movements. But although the goals varied, by and large, they wanted to create some kind of an Islamic state in Bangladesh because they thought that the current state of affairs was against or contrary to an Islamic state, and so they wanted to establish that. And so there's a group that's, I'm not sure, I think it's banned, but please do correct me. It's called the JMB. JMB has been responsible for several attacks in across Bangladesh, and a lot of their members have been tried and prosecuted, and some of them have been handed down death penalty for engaging in terrorist activity. So here was a case where two members of the group blew up a bus that was transporting two judges from their home to their official court premises. So the judges were just using the bus, the regular bus, to get to their workplace to start their regular day, and this bus was blown up by this group. And before they did that, they distributed pamphlets saying that the reason why we're doing this, the reason why we're targeting this bus, and in particular these lawyers, is because we think that Bangladesh is not an Islamic state, and it's the responsibility of the state to adopt Islamic law, or something to that effect. And because these judges are representatives of the state, so in other words, the judiciary is the face of the state, they are obviously upholding a law that we think is contrary to Islamic law. And so this was a highly symbolic attack. It wasn't just an arbitrary attack. It was very well planned and executed, and there was a message behind it. And the message was, as judges, you are upholding a law that we disagree with, that we consider to be contrary to Islamic law. And if you continue to do that, you will be under attack. Anyway, so members of this group who carried out the attack were tried in courts, and then they were awarded the capital punishment. The interesting thing about this case is the fact that the appellants in this case, in this criminal law case, argued that they just had one argument, really. And the argument was that we demand that we should be tried based on Islamic criminal law. So based on Sharia. So in other words, we want the court not to try us based on, or give us a verdict based on, the law of the land, which is the criminal code in Bangladesh, but based on the Sharia. And interestingly, when the proceedings were going on, some of them admitted that if they were given a death penalty based on the Sharia, they would be willing to accept it, but not if they were given the same kind of punishment based on secular law and given by secular courts, in this case by Bangladeshi judges. So this is a very sort of extreme case in the sense that it challenges the very foundation of the state. It's basically saying an appellant or a party going through the court and saying that I want this law to be applied or to be upheld, when in fact the country does not even recognize that law. Because in Bangladesh, Islamic law is very much circumscribed and is applied to only a handful of cases. That is not to say Islam as a religion doesn't influence, or Hinduism doesn't religion influence the jurisprudence of courts, but particularly matters of law, it is only in certain areas. So for example, in marriage, divorce, inheritance, waqf, these are some of the cases where religious law is in fact recognized, but not in the case of criminal law. This is obviously different from other contexts like Pakistan and Egypt, or even in Malaysia, where in some parts the criminal law is fully or partially based on Islamic criminal law. Okay, so in this case, the judges decide, not surprisingly, that they are not going to allow a retrial based on Shariat, because these people were tried by a competent court. They were tried according to the law of the land, and they were given a fair trial, and so they have to accept the verdicts that were given to them, and no special provision can be made for them. So this is a case which is really challenging the foundations of the state to begin with, and the state kind of responding by saying that no, this is something we can't allow, because if you were to allow this, you can challenge any and everything in the country based on religion, saying that this is something against religion. But I think the important thing to remember here is the fact that Bangladesh, unlike some of its peers that are also Muslim majority countries, as I mentioned, like Pakistan but in particular Egypt and Pakistan, it lacks a what you would call an Islamicizing clause. So there is no clause in the Bangladeshi constitution that says that all laws have to be brought into conformity with Islam, and so that's an important element that distinguishes Bangladesh from many other cases. And because of that, the courts are emboldened or are far more confident in saying that we're not going to recognize Islamic law unless the courts, you can find that in common law or in the constitution. So unless there's an express recognition, no other law could be applied on the basis of religion. This again can be compared to the Malaysian case, where the Malaysian constitution is similar in that it says Islam is the religion of the federation, but other religions are kind of free to follow their own religion. So the phrasing is somewhat similar to the Bangladeshi constitution, particularly Article 2A. In that case, back in 1988, there were these people who were tried for trafficking drugs, and in some Malaysian states where Islamic criminal law is applied, they were given the death penalty, so the capital punishment for trafficking drugs. So in that case, the appellants argued that the death penalty based or for trafficking drugs does not conform with the Islamic punishment for the Islamic criminal law punishment that is known as ta'zir. So in other words, they thought that if the Islamic criminal law was applied in matters of drug trafficking, they would not be given the death sentence. They were probably given a lesser sentence, probably, I don't know, life imprisonment or even less. And so they tried to make this argument that because the religion, the Malaysian state recognizes Islam as a state religion, they should be the Islamic law should be applied, in particular criminal law. The court, again, refused to do that because it said that nowhere in the constitution does it say that all laws should be based on Islam or should be brought into conformity with Islam. And because of that, what you would call a religionizing clause, courts are far more confident in upholding this. Okay. Now, the final case that I want to discuss is a case about, which is probably quite familiar these days in Bangladesh. It's a case about public disorder based on religion. Like, can you curtail the rights of individuals or groups if there is a threat to public disorder, especially when it relates to religion? So this case is called Junaid Doja, Marketing Director, International Book Agency versus the State. It's a case from 2001. So again, it's been a while since this case was tried. This case is really about, the key facts of the case are simple. So this book agency is basically distributing the magazine it's a popular magazine called the Newsweek, and they were publishing the Singaporean edition. So they were probably one of the distributors of that magazine in Bangladesh. They had the right to do that. Anyway, so in one of the issues of this magazine, there was a story done on an Iranian woman and activist, and the magazine, specifically the piece, contained a photo of the sole of the feet of a person, and there was Persian inscribed. So it's it's like almost like it's using Photoshop. Like imagine taking the sole of the feet of someone and just writing something or adding something using Photoshop, right? Like very easy to do. Anyway, so the inscription that was there was in Persian, so it was in Farsi, not in Arabic. The publication was the government issued an order that called for the seizure of the publication because they thought that this might incite or this might provoke some Muslims, because if Muslims were to find some like Arabic written in a place that's considered inappropriate, so in this instance it was the sole of the feet, that they might become offended, and so this might create a public order issue. So in this case, the question was whether the government order was in fact justified or not, because the argument of the magazine, or rather the distributor of the magazine, was that the inscription was not in Arabic, it was in Persian, so no offense was caused as such, because if we understand if it was Arabic, then we understand Muslims might get offended, but because it's Persian, it's Farsi, like it's not really disrespecting Muslims in any way. And plus, the inscription did not have to do with religion in particular. It was more about essentially it wasn't really about religion. So that was one. And the other argument of the book agency was that look, people are not going to read this magazine. People who are protesting outside and who want to ban this magazine, in fact, are not the regular readers of the magazine, and so it would hardly get to them. They can get offended if they can't see it or they can't read it. The governments argue that, of course, that's not really the case, and the courts, interestingly, in this case, decided that it's somewhat irrelevant if the inscription in the photo that was considered offensive was in fact Farsi or Arabic, for the simple reason, according to the court, that the vast majority of Bangladeshis who are Muslim, they might not be able to distinguish between the Arabic and the Persian script, and they might mistake the Persian script for being the Arabic one, and they might get offended based on that, and who knows what might happen after. And so they sided with the government in saying that it was appropriate to forfeit the publication, seize all the copies, because otherwise it might cause offense to Muslims. But what's interesting is how the court does not simply use the argument of public order or disorder, which is quite common in states, even in secular states, where you can restrict the freedoms of religious individuals based on this argument. But it was also the fact that the court thought that this was a deliberate and malicious attempt on the part of the magazine or on the part of the person who wrote the story to hurt the sentiments of Muslims, and therefore the publication should be banned. So, well, we can debate about this. Like this again is a case from 2001. We can debate whether or not Bangladeshis have the same sort of sentiment. Are they in fact unable to distinguish Farsi from Arabic? Would they in fact be offended by this image, or is this something that should be allowed? But the more important thing here is the fact that although the court is using legal reasoning in this case, you could very well argue that the court is simply trying to make a case for why offenses against Islam are punishable at common law in Bangladesh. So this is similar to a lot of cases in the US, in the United States, that came up in the 18th and 19th century, where it was quite common for one group to abuse or insult the other, or for non-religious people or skeptics to abuse, for example, the name of Jesus Christ. And so a lot of people would file cases against them, or would file blasphemy cases against them, and would say that their speech should be restricted because it's considered offensive. And in a lot of these cases, the American courts, in fact, did uphold restrictions on speech, which they thought was offensive. But what's important here, and keep in mind that although there's the establishment and the establishment and the free exercise clause in the U.S. Constitution, which is the backbone of American secularism, a lot of legal theorists, in fact, in the 19th century, argued that blasphemy is punishable at common law in the U.S. and that Christianity is part and parcel of the laws of the United States. This is an argument that was actually made by legal theorists, even by judges. And in this case, I think what's important to keep in mind is in Bangladesh, it's not entirely clear whether they actually think that it's the duty of the state to protect or to prosecute offenses that are specifically related to Islam, or whether the restriction is placed purely on the basis of public order. So let me compare that to the American case. In the American cases, when these cases came up, either for blasphemy or because someone was offended and there might be a public or disorder issue, a lot of the courts would argue that the reason why we're restricting speech, or let's say banning a publication, it's not because Christianity has some kind of special place in the system of laws in the US. It's because this might create a public order issue. In other words, if something non-religious is equally capable of creating disorder, public disorder, we will do the same thing. So in other words, the reason for restricting the speech is not because, as some legal commentators had it back in the day in the US, that Christianity is part and parcel of the laws of the United States. It's because this is a public order issue. In Bangladesh, it's not entirely clear when these cases come up whether they're deciding purely on the basis of public disorder, right, or to protect public morality, or in fact they're doing it because they think implicitly, not explicitly, but implicitly, that Islam is in fact part and parcel of the laws, or that offenses against Islam or insults against Islam are punishable at common law in Bangladesh. This is something that needs to be further clarified, of course, but as of right now, it seems as though the courts are more willing in taking up cases in restricting speech that have to do with Islam, but not necessarily when it comes to other religions, which might give the impression that the states are restricting the speech not purely based on public order arguments, but also based on the idea that Islam or offenses against Islam are criminal or considered part of. They can be penalized at common law in Bangladesh. That's something that would need to be clarified. Okay, so I will end there, and hopefully this gives you a brief overview of the kind of cases that come up. And again, this is not exhaustive at all. We can talk endlessly about what comes under the radar law and religion. But I just wanted to give you a slice of some of the issues that have come up, how Bangladeshi judges have approached this, and how this how this compares in a more sort of global context. Thank you.
Thank you so much, Mr. Kamal. That was really an informative session. Well, we have some questions for you. I'm going to just go one by one. After that, I will be taking the audience question. So, in the Hefjur Rahman versus Samsun Nahar Begum case, Justice Ghulam Rabbani, who has died, he gave a progressive interpretation of religion relating to maintenance. So this judgment, it was reversed in the appellate division by erstwhile Chief Justice Mustafa Kamal. Well, so how do you evaluate these interpretations?
So the Hifzur Rahman case, in my perspective, is a case about the autonomy of religious law. Like, is religious law something autonomous and simply applied by courts, or is it something that's also where the courts have the authority to interpret and change, if they can, based on the reinterpretation? So there are two groups. I think there are some people who are of the opinion that courts or judges are competent to reinterpret law. So they're not merely there as automatons simply applying the law, and not thinking about what the content of the law is or how this might apply or is applicable in the 21st century. But also the fact that they could, think about the larger context in which they're applying. And of course, there are others who argue that religious law enjoys a kind of immunity or autonomy from a state intervention. So in other words, and I'm thinking the court as being part of the larger state. So it's like it's not exactly synonymous with the state, but you can imagine how the court is a representative of the state. So in some cases, you would say that, especially in the Hifz-ur-Rahman case, the opposing party, they argued that Islamic law enjoys a kind of immunity from any kind of reinterpretation because all the courts have to do is to apply the canon of Islamic law as classically interpreted, and that's about it. In this case, of course, this is one of those high-profile cases that attracts a lot of controversy because it no longer remains about the specific litigants who are party to the cases. As we know, they were, I think, interveners on behalf of both sides who argued that the courts should have the power to do this or not. So my own sense is that courts in South Asia have always had the authority to interpret or reinterpret Islamic law. So they have not been simply appliers of the law, or like courts are not simply there to implement the law as is, because in common law, there is room for changes, improvements, and so on and so forth. So on the very specific question, are courts competent in applying, in reinterpreting law, especially religious law? Yes. But this comes with a caveat. So I was interviewing some judges, former judges of the Supreme Court on this issue, and I would ask, like, do you feel comfortable interpreting religious law? Like, do you feel that you have the capacity or the knowledge or the expertise to, think about religious law independently and then apply that? And in some cases, the judges had said that in most cases, yes, but of course there are cases of Islamic law which are beyond our competence, in which case we do refer to expert authority. Now, that's the important question. Who do they consider expert authority? Are these traditionalists? Are these reformists? Do they have a liberal orientation or a conservative orientation? That obviously matters. But the point is that they think that in most cases they are competent. In cases they are not competent, they seek official guidance. And then they decide. But by and large, they would argue that we have the authority and capacity, and it's something that actually judges have been doing across the Muslim world. So it's not just in Bangladesh, right? As to the question of, as to the question of whether post-divorce alimony can be awarded, in this case, my sense is yes. The question is, can it be awarded for a lifetime? I think that's the key question. Like the specific question in that was, it wasn't a lifetime, it was until the person remarries, which could last for a lifetime. I think this would really depend on the case. You can't come up with like in this case, the person might have been entitled given the background, but as things progress and change, because at the time the circumstances were different. So the larger point here is that I agree that courts have the power to reinterpret. Whether or not the new interpretation that they come up with is in fact reflective of or is true to the methodology of Islamic law, that will always be an open question. But I think they do have the power to do that.
Oh, okay, thank you. Well, if I move to my second question, well, there is something like, another point from your perspective, I want to know, this Justice Mustafa Kamal, well, he was it's very interesting that he was named after Mustafa Kemal Pasha, a progressive leader of Turkey. Wow. So what do you think, about this progressive, progressive mindset of this two, Justice and Pasha? Like, what's your opinion on it?
So my understanding is that despite his name and his moniker, that his judgments are probably not championed by within liberal circles, because he would err on the side of conservatism when it came to Islamic law. On the specific question of progressives like Ataturk, so I think the key issue with any kind of secularist project, like a Turkish secular project, is that it cannot actually remain secular, because secularism involves, in some respects, it involves independence of the state from religion, but also religion from the state. So in the US, for example, a lot of the times the concern is that courts should not decide theology. Courts should not intervene in matters of theological disputes. This is something that should be left to individuals. All we can do is apply or intervene in a case that has a secular sort of nature to it. And this is considered one of the fundamental principles of American liberalism and secularism, that religions, religious authority, religious institutions, and religious individuals, they should have autonomy from state interference and decide in the state saying this is right and this is wrong. And I think the challenge with the Turkish project is that it begins by contravening with this very first principle, because it wants to dictate who is sort of this ideal progressive Muslim and who is not. We know that in the Turkish case, the entirety of Islamic law in some case was eradicated and was not applied. So, for example, the inheritance law was changed and was replaced by Swiss codes, even though to this day, a lot of people in Turkey still unofficially apply the Islamic law, but officially that's no longer the case. And then, of course, that could be said of any number of cases where Islamic law used to be recognized. So I think the danger in pursuing a Turkish-style secularization project is that it very quickly descends into the state trying to control religion as opposed to keeping a distance from religion. And by controlling it, obviously, it would invite controversy. It would invite controversy from all groups. So it would invite controversy from conservatives in cases like, for example, Hifzur Rahman. But it would also invite controversy from liberal activists, because what if the state wants to dictate who is a good or an ideal Muslim, but my understanding of Islam or Hinduism or whatever is different? Like, should I be compelled or coerced by the state to formulate my beliefs in a certain way, or to reform myself so that I become acceptable in the eyes of the state? That's a very sort of tricky thing to do. So I think the more sort of realistic option that is not just achievable, but also respects the principle of secularism would be these piecemeal changes, right? Like these changes that come up not as a kind of a revolution from the top down, but as these small cases that come up that try and reform Islamic law. But the debate would always remain in that.
Thank you. Well, my next question too is a similar but general question. So how do you theorize the politics of interpretation of religious text by the constitutional courts in Bangladesh and beyond? And whether Bangladesh should continue with its legal pluralism or embrace uniform family law, incorporating equality between man and woman? And what is the position of Bangladesh courts in this regard? Well, I have asked the question at this time.
That's a sort of difficult question to answer. It's a very broad question. It's an important question, but it's a very broad one. So I would say, yeah, sorry, go ahead.
No, continue. Like, do I just go one by one from the beginning again?
No, so I get the gist of the question that you're asking. So there are two competing perspectives in Bangladesh about the status of religious law in contemporary Bangladesh. On the one hand, are people who argue that religious law is a creation of state law. So it's a creation of the statute or the constitution. So in other words, if the constitution or the statute recognizes religious law in a specific sort of area of law, that's when we apply the law, and that's pretty much it. In which case, of course, you could also change the law, because you could say that as amended by the constitution, or as amended by statutes, or even as amended by common law. That's one perspective. That's the perspective that was actually taken by the British Indian state. So when India was colonized by Britain, this controversy came up in courts. What's the status of Islamic law? And a lot of judges would take the position that Islamic law has no value whatsoever unless it's expressly recognized by the statute and the constitution. In which case, the idea was that because it's not a supreme law, it would have to conform with whatever amendments were made by the legislature or by common law through judges. So that's one perspective. The other perspective is, of course, that religious law predates or precedes the state. It's not a creation of the state itself. It existed prior to the state, especially rise of the nation state as we know it. And so the state, it doesn't owe, in other words, it doesn't owe its existence to the state, but to an extra state or extra constitutional authority. And the state has an obligation or duty to apply it as is. And it cannot change it in any way, or at least cannot change it on purely constitutional arguments, because it enjoys this kind of immunity from constitutional challenges. And this is very much reflected in Bangladesh. So I'll give you one example of this, where it actually has it's a case by Justice Ghulam Rabbani as well. So this was a case where a person had left behind a will, and of course some provisions of the will contravened parts of Islamic inheritance law. And one of the daughters of the person who had died had challenged the will by saying that I should get a share that's based on Sharia, that's based on Islamic inheritance law. I should not be getting a share based on what's in the will. And Justice Ghulam Rabbani was one of the judges who was presiding the case. This is from the 90s. And this is an extraordinary case because in that case, Justice Rabbani argued that both the 1/3 rule and the limitation on making a Quranic ayah beneficiary of your estate are not, strictly speaking, part of Islamic law, that these are kind of optional. Because he made this argument about how the bequest verses in Surah Baqarah did not contravene the inheritance law that came in Nisa. Like these are two independent laws, and one doesn't override the other. It's an extraordinary case because it basically goes to the very root of Islamic law, especially limiting the power of testament, and says the 1/3 rule and the prohibition in apportioning a share to the Quranic heir, these are not applicable if a person makes a genuine will. Like those are not applicable. Not a surprise that this case would be considered controversial, because since then this case, I believe, has been reversed, because courts to this day uphold that in Islamic inheritance law would apply in Islamic inheritance law cases, and any will that deviates from that would be considered void, or at least that aspect of it. So with respect to in reinterpretation, I would say that I think reinterpretation based on what? Are we talking about constitutional principles, equality, for example, before the law, gender equality, some other kind of equality? Is that the principle? Or if that's the case, then you've already accepted the argument that religious law is a creation of the constitution and the state, that it doesn't enjoy independent existence. And so in that case, you would probably be open to changing it however you want. If, however, you believe that religious law does not owe its existence to the state, but is independent of it, you will be far more circumscribed and far more sort of careful in changing the law, because you think that constitutional tests cannot be used to challenge religious law. One final example I will give with respect to that is a case of preemption. So preemption obviously has to do with property. It's a very specific type of right that's given to individuals in undivided property. There's a case from 2014, I believe. Sorry, not 2014, 2006, where the presiding judge was a companion judge of Sayyid Justice Ghulam Rabbani. His name is Sayyid Amirul Islam. So he was one of the presiding judges in the cases where he struck down the Muslim law of preemption on the grounds that the Muslim law of preemption gives an undue advantage to a Muslim Bangladeshi, but a Hindu Bangladeshi has no choice but to resort to the statutory law of preemption as found in the State Acquisition Act. And so one of the arguments that he used to strike down the Muslim law of preemption, which was eventually reversed by the appellate division, but the point is that his argument was that the law of preemption, again, it's of Islamic or Arabic origin, but the religious law itself owes its existence to recognition by the state, and so the state has the capacity to repeal or to amend a religious law as they see fit. So I think it depends on what perspective you take. Like, is it one or the other? Like, is religious law preceding the state, or does it come after? So that's that would really tell us what courts think about reinterpreting Islamic law.
Okay, thank you. I have more questions actually. In the past, you worked on this consociational theory. So, do you think this theory advocates for a legal pluralism, or could we call the approaches taken by Bangladeshi courts consociational?
So you're asking whether Bangladesh would be considered consociational, or?
Yeah, the approaches taken by Bangladesh, and also if this theory advocates for legal pluralism.
So, for those of you who might not know what consociationalism is, consociationalism is the idea of power sharing between the major groups that exist in a society, because in the absence of this power sharing, there's a fear that there might be civil war of some kind. So you can imagine a lot of contexts. You can imagine British India, for example, where there was a lot of conflict between Hindus and the Muslims, and they were both fighting for power and recognition by the British Indian state. But there could be any number of cases where people are divided based on ethnicity, based on language, based on sectarian divides. So think of contexts like Northern Ireland, Malaysia, Israel, Palestine. These are all cases where very fundamental divisions exist, but either based on race, ethnicity, language, religion, and so on and so forth. So consociationalism is basically a political model to manage differences by making sure that each group within society gets some kind of recognition and power within the state. Because otherwise the fear is that the majority would simply use its demographic weight to crush the minorities. But if you guarantee minorities a certain amount of power, if you give them political power, the chances of them getting sort of exploited by the majority are reduced. So that's the basic principle or premise behind consociationalism. Now, what's interesting about legal pluralism is that although this obviously is a form of consociationalism, in many of the contexts where consociationalism was adopted, they don't have a legally pluralistic regime. So just to compare Bangladesh to Northern Ireland, in Northern Ireland there has been a long-standing conflict between nationalists and unionists, or Protestants and Catholics, and they've been fighting a war for many years. Basically, one group wants to remain with the United Kingdom, so they are unionists, so they want unionism. The other group wants to reunite with Ireland, and so they are called Republicans or nationalists. But in Northern Ireland, inheritance law is not based on religion or even sectarian differences, because we know that in Christianity, technically, there is no law of inheritance. They don't. So in many of the European countries, they have their own statutory law of inheritance or based on custom. So it's not based on religion. So in the sphere of inheritance law, there is no legal pluralism. But we know that in other contexts, like in Bangladesh, in India, in Malaysia, even in Singapore, these are contexts where inheritance law is based on legal pluralism, and this can be considered a part of consociationalism. On the question of whether on whether we should have a uniform like code or not, I think it's very unlikely that a uniform code would be adopted. A more sort of likely scenario is reform within existing religious systems, especially reform that is necessitated by challenges that come up in the 21st century. But I don't think the problem can be resolved by adopting a uniform civil code.
Thank you. Well, my questions for you. Well, in liberal democratic constitutionalism, the right to property is an inviolable right, and it also preaches equality between men and women and among various religious communities. So this right to own, hold, and alienate property is well, a fundamental right. So do you think the right of preemption violates the right to property? And what is the position taken by the Supreme Court of Bangladesh and Pakistan in this regard?
So from an English common law perspective, yes, preemption restricts your right to alienate or acquire property, because preemption is a condition applied to undivided property, whereby if you want to sell your share, you have to first offer it to your co-sharer or the co-owner of that property. And if they decline, so it's a kind of a right of first refusal. And if they decline, that's when the person can basically sell it to a third person, like a total stranger. So from that perspective, preemption is considered a restriction. But we have to keep in mind that if you think of Islamic property law, all sorts of limitations were accepted on the basis that there was some kind of moral reasoning behind it. So back in the day when Islamic property law emerged, or even the law of contracts emerged within Islamic societies, there were things that were considered prohibited because they might cause certain harm. You couldn't, for instance, buy. So if you're growing, let's say, a certain fruit on your piece of land, and you want to sell that produce to a person, in Islamic contract law, you couldn't simply buy based on the seeds that had just been what's the term here? Again, I'm not a student of agriculture. That had just been sowed, right? So if you have just sowed the seeds, you couldn't potentially buy based off of that, because you don't know what the produce would be like, because it will be several months after the sowing of the seeds that you would see the results, right? Like the fruits would be grown. Okay. And the reason why it was prohibited was because it's speculative. You don't know what the actual result or the produce of that yield would be. And it might cause the buyer enormous sort of economic loss if they only bought based on what they saw in the initial stages, but then it did not actually produce the yield that you were expected. So the point is that you are limited in what you could buy and sell, but there's a moral principle behind that, and that's saving you from some kind of loss, right? Like some kind of harm, economic harm, political harm, other kinds of harms that might happen. Preemption is part of this larger category of harm within Islamic contract law, that if you were to sell property without informing your co-sharers, a third person might buy property, and that might inconvenience you. We can obviously debate the merits of this law in the 21st century, but the larger point here is that from an English common law perspective, yes, it is considered a limitation. The case that I was referring to earlier by Justice Islam on preemption, he actually used one of those arguments to argue that the right to property is guaranteed in the Constitution of Bangladesh. That includes the right to freely acquire and alienate property. But preemption poses a restriction on that. And so on those grounds, this is considered like a bad law that should be struck down. In Pakistan, the courts, so in Pakistan, only the Islamic version exists. So there is no statutory version that's found in the NAT, Non-Agricultural Tenancy Act, and the state. So the state acquiring property either of non-agricultural or agricultural lands in Bangladesh, they both contain preemption provisions. So we don't see that in the Pakistani context. In Pakistan, it's based on the classic Hanafi law of preemption. And there they have upheld, what's interesting about the Pakistani courts is they actually also admit that from the point of view of property law, even Islamic property law, preemption is considered a limitation on your right to alienate or acquire property. But they defend it by saying that this is a highly restrictive law. So it's not as if you can take this law casually. There are these formalities you have to fulfill. And if you fail in any of those, you actually forfeit the right of preemption. So that's one. So that's one of the reasons for granting it. But the other one is, of course, based on the harm principle that you might face some kind of potential social or economic harm if this law was removed. So far, but the other thing I wanted to mention is that preemption, it seems, has declined in usage. So as property relations become more complex, preemption is not as common. I don't have any facts or figures, but I was interviewing a commercial lawyer in Bangladesh, who told me that in the last decade or so, he hasn't really seen any preemption cases come up in Dhaka. And the reason why he cited was because the formalities of the Muslim law of preemption are far more stringent than the statutory version. And B, because if you start litigation based on preemption, it takes years and years and a lot of legal costs to actually pursue these cases. And so it has already become a deterrent. So it's quite possible that although preemption might stay on the books, it might still be recognized by courts, but it actually might fall into disuse simply because it doesn't gel well with developments in property and how people buy and sell property in South Asia.
Okay, thank you. Well, now we'll be taking questions from the audience. I can see Mohammad Reza Rahman Shibul sir. He has asked a question. Well, the first is, what is the basis for the court to decide the proper interpretation of Islamic law?
So if the question is about constitutional basis, the answer is simple. If you recognize religious laws based purely on the idea that it's a creation or it's a creature of the Constitution, then using the same Constitution, you can reinterpret the law. But I think if the argument is on is there any legitimacy on courts, secular judges interpreting Islamic law? Like, what gives them this right other than the Constitution itself? Like, where does the legitimacy come from? Then I think the answer would be that even historically, although the offices of the Mufti and the Qazi were separated. So the Mufti would be the one who would give an opinion on a certain Islamic matter, and the Qazi would be the one who would apply it. And the Qazi was not necessarily bound by the opinion of one Mufti. He could potentially approach different opinions and then select one of the two and then apply it. I think the same could be said of secular courts, where judges are not bound by their own sort of perspective. Like as I mentioned, some judges that I spoke to were open to the idea that in some matters they're not experts, and so they would call different parties. I think the key here is who they are calling, right? Like what are their credentials? What kind of worldviews do they espouse, and what kind of interpretive authority do they have when it comes to Islam or even in Hindu law? And judges can then decide between competing perspectives what's the most appropriate way. In that sense, they're not necessarily contravening one of the rules, which is that the opinion of a mufti, or like if the canon says something, you could possibly pick one of the sides in the debate and say that this is an opinion that's more in line with our interpretation, and that's how we can apply it. So I hope that answers the question.
Well, then there's this another question. When JMB, the case that you referred earlier about the criminal case, maybe it was a third or fourth case. Well, so when JMB demanded that they should be tried by Sharia law, did they make any legal argument?
So there were two arguments. One was right to a fair trial. So it's basically saying, it's using this argument to basically say that, according to us, a free trial would mean free trial basis on Sharia law. So that's one. Although this did not come up explicitly in the judgment, but you could sense that one of the arguments that they wanted to make perhaps was the fact that at the time, Islam was recognized as a religion of the state in Bangladesh, and it continues to be recognized even to this day, even after the amendment that restored secularism as a founding principle. So it's not explicitly clear from the judgment, but you could sense, reading some of the arguments of the lawyers representing these clients, that they want to make this argument that there is an obligation on the part of the state to apply Sharia law because Islam is recognized by the state. But the actual legal argument was basically on this idea that these appellants have the right to a fair trial, and they should be retried based on some of the law.
Okay. Well, I think I don't see there are any more questions. So, Mr. Kamal, thank you for your time, and thank you on behalf of Bangladesh Institute of Research and Education. I'm sure, after this 1 hour, whoever is listening or is going to listen to this session, they will have the increase on the increase of knowledge on this Bangladesh course on religion will just increase by twice, if not more. Well, if you don't have anything else to say to the audience, I think we can end our session here.
All right, thank you. Yeah, thanks very much for the opportunity, and I'm glad that we had the discussion today. Thanks.
I guess. Yes, thank you again.
So should I click